My name is Tom Dugan. My business address is 900 Main Avenue, Durango, Colorado. I'm an oil and gas attorney, and I do work for ConocoPhillips Company, and I've practiced for 38 years, and most of my practice has involved oil and gas, and a large part of it has involved relations between local governments and oil and gas operators. I've been to the Colorado Supreme Court on the preemption issue, and I probably have negotiated about 20 MOUs. So I'm here to answer some questions if you have some, but also I wanted to present some comments on the MOU draft that you have before you, and also the proposed regulations in section 27. I have a letter which in detail runs through some of these changes. Some are minor and typographical. So what I will do to keep the time short is focus on some of the high points, and then I'll give you all a copy of the letter to put in the record.
That would be fine.
Whatever the process is. When you look at the MOU, the body is not very difficult. You might want to define the company or operator instead of leaving a lot of blanks in the form, so you can avoid typographical errors later. The primary areas of concern would be in the addendum A, and out of all the numbers, I have 4 that I think are problematic. One is the setbacks, which is in number 1. It calls for 1,320 feet for a setback to a house. I can tell you that in La Plata County, which has probably been the most aggressive county in terms of oil and gas regulation in the last quarter century, has a 450-foot setback. And in none of its MOUs is that subject addressed. With respect to number 2, having to do with notice, I think a mile notice area, again, is a little extreme in terms of what I've seen in MOUs. We have no problem with number 3, no problem with number 4, same with number 5. Conoco uses closed-loop drilling system. With respect to number 6, I think 90 days is an unrealistic time to say, put in your gathering lines, your pipelines. That timetable depends on so many factors. You know, is it winter? Do you need a permit? Is there snow on the ground? Are materials available? I just think putting a time frame, especially that short, in my experience, is not realistic.
What would be a reasonable time?
I wouldn't put one in. It depends. I mean, the company has an interest in.
We have forever infinity.
Yeah.
Go ahead, sir.
Gentleman talk.
The company has the interest to produce the material, the production as soon as possible, and start to pay royalties and pay taxes. So it's not going to drag its feet. It's just that, you know, how long is the line? What kind of soil is there? What kind of pipes are going in? What's the weather going to be? I can come up with probably 20 factors that would affect this. With respect to number 7, water well testing, the COGCC recently adopted Rule 609, which was based on days and days of expert testimony. We think Rule 609 should be the governing standard. It's very thorough. We have no problem with number 8, no trouble with 9 or 10. I have some comments on section 27, but I'd just like to discuss the MOU for a second. I think what you're going to find is that if these items are too extreme, operators or persons are not going to sign it. And the reason is, as Carol mentioned, you know, it is a contract. It's a binding contract. It's not a regulation. And persons and operators are not going to sign it and then hope that it gets renegotiated or amended, which seems to be the concept behind this. And if the MOU doesn't get signed, I think both the operators and both the county are going to find themselves with an inefficient system that takes a long time and is time consuming on both sides and pushes back or pushes out the benefits from the program, you know, taxes, royalties, and so on. So I don't know how much time I have, I can go through section 27.
No, just give us your letter and then we'll.
Okay, that'll be fine.